Good morning, children. Today we will continuing this lesson, Indian Judiciary, and today the topic will be power and functions of High Court. Children, when we were discussing about the power and functions of Supreme Court, there we discussed about the original jurisdiction, appellate jurisdiction, the powers of Supreme Court. Children, here in High Court, in the case of High Court, the powers which has been given to High Court regarding original jurisdiction, that is little bit limited if we compare it with the Supreme Court. Now, what cases will be deal under this original jurisdiction by High Court? Like violation of human rights, if there is any election of any problems related to the election of MPs and MLAs, that is members of parliament and legislative assemblies. So, in High Court is also a court of appeal, both in civil and criminal cases. If we are not satisfied with the decision of lower court, we can appeal to High Court. So, it is brought before High Court against the decision of lower court. So, this comes under appellate jurisdiction. And what cases will come under original jurisdiction? Like violation of fundamental rights, elections. These will come under the original jurisdiction of the High Court. Now, in every states of India, we have High Courts, and the High Court at Chandigarh is a common for the states of Punjab and Haryana. It also covers the Union Territory of Chandigarh. In Delhi, there is also the only Union Territory which has its own court. Why? Because it is the National Capital Territory. So, these are the cases related to appellate and original jurisdiction. The cases pertaining to marriage, divorce, laws, wills of the deceased persons are also taken by the High Court, and the High Court also has the power of judicial review. It can transfer to itself those cases where substantial question of law is involved and require interpretation of the Constitution. Interpretation of the Constitution means if anything has been done which is not against the provisions of the Constitution, there itself the case will be transferred to High Court and it will again review those decisions. Exercising its supervisory jurisdiction, all the subordinate courts in the state concerned functions under the control and the guidance of High Court of the state. So here supervisory function also comes under High Court. So these are the supervisory functions. Like the Supreme Court of India, High Court is also a court of record. Obviously, all the proceedings taken place in the High Court is all been kept as a record. All the decisions of High Court are binding on lower courts who are bound to follow it. They are cited as precedents. Underline that, children. This is important. Please, you should know this term, precedents. Means whatever decision is given by the High Court, it will to the lower court, it will be binding to the lower court to follow it. Next is subordinate courts. Subordinate courts are the lower courts at district level and below. They are supervised and controlled by the High Court of the concerned state. Now, they are civil courts, criminal courts, and revenue courts. In subordinate courts, there are 3 layers. Besides these lower courts, there is a provision for Nyay Panchayat and Lok Adalats also, as you have read in class 6 in rural governance. Each state of India has its own system of court, but the general pattern is the same. So subordinate courts are only lower courts, and they under this in this lower court there are civil courts, criminal courts, and revenue courts. So let's come to first civil court. The highest civil court in a district is called a district court. The judges of these courts are appointed by the governor in consultation with the High Court. Obviously, by the governor because it is under the state. All the civil matters. Now, what are those civil cases? Like landlord, land tenant disputes, contracts, agreements, property matters regarding or related to property, which do not originate in High Court are heard in the District Court. Yes, which do not originate in the High Court. That is the big point over here, because as I told you that in High Court the original jurisdiction is little bit limited. It is not vast as like Supreme Court. So it is not originating in the High Court. It is been heard in the District. Below the district court, there may be one or more courts of sub judges. Separate family courts are also there. They hear cases of family disputes like divorce, custody of children, and below them are the court of munsifs. So, in civil court is district court, and below district court is court of sub judges, and below court of sub judges is court of munsif. So, how we will distribute this? This is under the civil court is your district court. Below district court is court of sub judges, and below is the court of munsif. Again, in criminal courts there are three categories. First is your the highest is session judge. Below it is the magistrate of first, second, and third class. And first class magistrates are only called metropolitan magistrates. Now, below session judge, there are first, second, and third class magistrates. And first class magistrates is only called metropolitan magistrate. So, these are the division of civil courts and criminal courts. Now, next come to revenue courts. The highest revenue court in a district is the Board of Revenue, which deals with land cases, land revenues. The Court of Commissioners, Collectors, Tehsildars, and Assistant Tehsildar works under the Board of Revenue. So, this is the highest revenue court. So, you can get a question that which is the highest revenue court? The Board of Revenue. Below it is Court of Commissioner. Under this Board of Revenue, Courts of Commissioner, Collectors, these are the officials working under this Board of Revenue, which hears the final appeals against the lower revenue courts. That means Board of Revenue is the highest, below it is lower revenue court. So these are the officials who, if someone is not satisfied with the lower revenue courts, they can appeal to the Board of Revenue, which is the highest revenue court. And these are the officials, collector, tehsildars, and assistant tehsildars, who deals with the cases or appeals against the lower revenue courts. Next topic is your lok adalats, which is very, very important for you. It is said that justice delayed is justice denied. Obviously, in our country, justice is not an easy process. It takes a lots of time, and sometimes, not sometimes, several times we have seen that common people, they give up. They don't have so much patience because it needs patience and also money. And many times people don't have so much money to invest those money in these cases, and still they don't get the desired results. So that's why in our country it is called justice delayed is justice denied. Many people thinks that. Since the process of imparting justice is very lengthy and expensive, it is becoming out of the reach of common. As I told you just now, that as the people thinks that the justice delayed is justice denied, so many people, common man especially, don't want to go to the court because it takes time, and it also needs money. It is very expensive. The cost of the lawyers, the fees of the lawyers, especially. Beside, thousands of cases are lying pending in various courts. 10 years, 15 years, 20 years. It takes lots of time. As an effort to simplify the legal procedures, reduce the cost of litigation, and to provide speedy justice, Lok Adalats had been set up. So, what was the purpose behind the setting this Lok Adalat? To get speedy justice, and the cost of the litigation was very high for the common man. It was out of the reach of common man. So, it reduced the cost of litigation. It provided speedy justice, and it also made this legal procedure simple and easy by setting up this Lok Adalats. And it was set up in 1985 when the first Lok Adalat was set up in Delhi. You will get a question, please underline it, children, that when it was set up and where. It was set up in 1985 in Delhi. And for the first time, 150 cases were been settled on the same day. On one day, 150 cases were solved. And this question last year came. So please note it down. Lok Adalat is normally presided over by retired judge. The disputing parties plead their case themselves. And the main thing is that no advocates are needed. Means the disputing parties, the two parties will lead this case. Even witnesses are not also examined. Efforts are being made to settle the disputes through compromise. This is the main thing. What is the main positive thing of this Lok Adalat? That the disputes are settled through compromise, mutual agreement, and on the spot decision. And also one more thing is that no advocates are needed. This is also one of the advantage of setting up this Lok Adalats. The idea of this Lok Adalat was mainly advocated by Justice P.N. Bhagwati, a former Chief Justice of India. This idea is based on the ancient Gram Panchayat where the judges were known as Panch Parmeshwar. Mahatma Gandhi had also strongly pleaded the revival of Gram Panchayat to settle dispute without wasting time and money. That's why Lok Adalat is also called People's Court, because it has been made for people, for speedy and inexpensive justice. So that's why it is also called People's Court. So please underline it, children, that Lok Adalat, why Lok Adalat is called a People's Court? Why Lok Adalat is called a People's Court? Because it is made for the common people to provide speedy and inexpensive justice. For providing speedy and expensive justice. That's why it is called, Lok Adalat is called People's Court. And it is very useful for the common man. So children, please go through the video, and in my next class, I will continue public interest litigation. Thank you, children.